Welcome back to Krishna's Laurels. Today we'll be talking about Article 20, which deals with protection in respect of conviction for offences. Here we'll be seeing some rights which are given to a person who has been arrested or has been prosecuted for any specific offense, like someone who is under trial or is under custody for committing of any offences. Our Indian Constitution grants protection to a person who has been convicted, who is also known as accused. For example, if I have uh, attempted theft and I have been arrested, I am under police custody. So I'll be known as accused. So I have some rights which have been granted by Indian Constitution under Article 20. So here these rights are available when a person is arrested or punished arbitrary in a sense, in a wrongful manner or in a falseful manner, or excessive punishment in a sense, if in our law the punishment is written, say 1 year of imprisonment, and that person is undergoing 3 years of trial. In a sense, that person is in jail for 3 years and still he didn't get the judgment. So for theft the punishment is 1 year, but the trial is going on since 3 years. So his here the case is excessive punishment. Therefore, the citizen here in Article 19, as we saw, the rights, those 6 rights under Article 19 were only guaranteed for the citizens of India, whereas under Article 20, these rights have been guaranteed to citizens of India as well as for foreigners and even the legal persons. Legal persons are like companies, LLPs, or partnership corporations, any company or any partnership which have been registered under MCA or Government of India. So here we'll be seeing about ex post facto law, which means imposing something which is backdated. What do you mean by backdated is, say I have committed a crime way back 10 years back, and today a law have been enacted. Today in 2024, a law have been enacted that if someone will steal something, they'll be punished for 2 years. But I have stole something like very minor 10 years back in 2014. So they can't impose this thing, like even if someone have theft something 10 years back, even those persons should be punishable with this, like today's law or today's rule. So here we are saying ex post facto laws are something which are retrospective, in a sense backward in date, and this have been prohibited in Article 20. The enactment of such law is prohibited in the criminal cases. So under Article 20, what we'll be seeing is no law should be applied backward, like retrospective. Retrospective, in a sense, it shouldn't be applicable for the past offenses, it should be for the continuing years. So but in civil cases or in a tax laws, in civil laws and tax laws, retrospective effects are applicable and they are valid. So if government want to impose tax on anything from today, and they are saying that we'll even consider it, whatever smuggling or whatever kind of trade have been happened in, for example tobacco, will example tobacco, the tax rate in tobacco 5 years back was 5%, but today government had changed it to 10%. Now government is saying it will be affected retrospectively, so every person who is dealing in tobacco will be charged heavy. So this is applicable as per law. Here, under this provision, it only prohibits convictions or sentence under the criminal laws and not on the trial. So this thing is prohibited on the punishment or under trials. Like there is a difference between the punishment and the trial. If someone is undergoing the trial, then this law can be applicable. But if someone, it can't be applicable on the punishment. Like if today's punishment is 10 years, and past when the person have committed permission like that particular offense, at that time the punishment was 5 years, then that person will be entitled only for the 5 years of imprisonment, not for the 10 years. This is what they are saying. So here in short, what we understand is this ex post facto laws are only applicable for the criminal laws or criminal punishments, not for the civil nature. This immunity is only for the criminal nature cases and not for the civil or tax laws. Here they are even saying the protection or immunity under this provision will not be applicable on the cases where you are detained for the preventive detention. What do you mean by preventive detention? Means if uh, police officials have a benefit of doubt on you, if they doubt that might be you are planning for any kind of crime, or else you might do any kind of mischief, so they'll detain you. In a sense, they'll arrest you for few days. That is known as preventive detention, and you can't get the protection under preventive detention. Or if any person is demanding security from you, if say someone have complained against you stating that you are stalking them, or they are afraid that you might do anything to them, at that time as well you can't claim this immunity, or you can't claim this protection under the ex post facto law, article 20. Here in article 20 there are three provisions, that is 21, 22 and 23. So 21 is no ex post facto law, same what we have seen in introduction. So here they are saying no person shall be convicted in a sense arrested or taken into custody if that person had committed any offense which was not a violation of law at that time period. In a sense, 2010 mein, what I did was I have smuggled drugs, but at that time it was not any kind of crime, it was not any kind of violation of law. But in 2024, it is a crime. So I can't be convicted for it because at that time it was not a crime. Here coming to 21(2), that is subject to a penalty greater than the that prescribed by the law in force at the time of commission of act. Ante something when I have committed a crime in 2010, same example. At that time, penalty for that particular crime was 10,000. But today in 2024, the penalty became say 10 to 40,000. Now I have committed crime in 2010. I can't be imposed 40,000 as penalty. I should only be imposed with 10,000 because at that time when I committed crime, it was 10,000 as per law. Now coming to 20B, that is no double jeopardy. So if you want to remember it, you can remember like this: double in a sense, no person can be punished twice for the same offense. What do you mean by twice for the same offense? So if I have committed a theft, I can't be prosecuted and punished. So here the main key word is prosecuted and punished. Even if you're prosecuted twice, there is no problem, but you can't be prosecuted and punished twice. In a sense, main keyword under this is punished. One person can't be punished for the same offense twice. Hopefully you understand. I have committed murder. Okay, I've committed murder. I went under trial. I went under prosecution. I have been punished for first 25 years of term. And again later on, police people have find some other clues, some other evidence against me. Now they have reopened my file, they are prosecuting me again, they are trialing me again, and now they have changed my what you say sentence punishment into life term. In a sense, until and unless I'm alive, I'll be in jail. It is not allowed because already my case have been decided and I am prosecuted as well as I am punished. If in case I was only prosecuted and later on I was given no punishment, then at that time they could have opened my files because I was not punished. So if I was not punished, I can be prosecuted twice. But once I am punished, I can't be again prosecuted and punished. So main term is no person can be punished for the same offense twice. But here there is again an exception that the proceeding should be in front of court of law or any kind of judicial tribunal. If you if the proceedings were before any administrative authority which was not of a judicial nature, then it will not consider that prosecution, which means that proceedings, the first proceedings which we did, should be in front of any judge or in front of any tribunal. What do you mean by tribunal? Consumer forums, or what do you say, any kind of DRT, NCLT, if you know, National Company Law Tribunal, and consumer forums. In front of those tribunals, it is okay. In front of magistrate, in what special courts, these all things are fine. But in front of any administrative authority, will not consider it as what prosecution. Third and final one is no self-incrimination. Self-incrimination, in a sense, one person giving evidence against him. I am culprit, I have been arrested, in a sense I am accused. Now police is forcing me to give evidence against me. In a sense, me myself should give evidence, that too against me. So it is not allowed under Article 20 Clause C. No self-incrimination. So here key point to remember it is self. You can't self-harm, right? So here, no person accused of any offense shall be compelled to be a witness against himself. How I can be witnessed against myself? Because I have right to protect me. The protection against self-incrimination extend to both the oral evidence and documentary evidence. In essence, I can't give any oral evidence against myself, and I can't even produce any kind of document which is against me. But I should, what things I should give? Compulsory, I should give material objects to the police for investigation. Like if say there was a crime scene and I was wearing a shirt on which there are blood stains, so they are asking me that shirt to give, so I should give that. I can't say no, I have right against self-incrimination. No, I should produce that material. Second one is I should give my thumb impression, specimen signature, blood specimens, in a sense DNA, thumb impressions, samples and all. Compulsory exhibition of body, in a sense, when someone commits a crime, later on when the accused, in a sense the suspect, when they take them into custody, first thing they do is their medical checkup. They'll see any scar or any mark. First say they'll note it down everything. So these three things should be done. These three things are not covered under self-incrimination. Further, it only extends to the criminal proceedings and not to the civil proceedings. In civil proceedings, you need to give your statements. You can't say in civil proceedings that I have right against self-incrimination. So here, if we see in a brief thing, three rights: Article 20A, Article 20B, Article 20C. These three are in case of criminal proceedings only. This right, Article 20 is only up to criminal cases, not to the civil cases. And even if you're arrested in any other case, something like apart from criminal case, you will not be having these three rights. So you can't say in civil case that I have right to self-incriminate, right against self-incrimination, double jeopardy, or exposed facto law. You shouldn't say all those things in civil cases. So hopefully you remember. We'll just have a recap. We saw three provisions under Article 20, and Article 20 is guaranteed to the criminal laws only, criminal cases only. No ex post facto law, in a sense. If I have committed any offense at that time, if it was not considered as offense, I'll not be trialed or I'll not be liable. Second point under this is, if today I have committed any crime, then I'll be charged with the penalty what is applicable in today's law, not tomorrow's. No double jeopardy, in a sense, I should not be prosecuted and punished in double courts, because if I'm only prosecuted, then I can be again prosecuted and punished. But once sentence is given, in a sense, once prosecution is completed and I have been given punishment, then no one can ask me to again come back in trial, because I have already been punished. Third one is no self-incrimination. In a sense, I should not be witness against myself. But whereas I should, not can, I should give what? Compulsory material to police, thumb impression, DNA, blood samples, and compulsory exhibition of body. These three things are compulsion, and these three rights are only extended to the criminal proceedings and not to the civil proceedings. Huge discounts are going on mega mock test series. Please do join. We have link in description. You can ping us in WhatsApp or in Instagram.